Honorable Secure Court is back in session. The Honorable Judge Randolph is out. Good morning, Your Honor.
Good morning. Please be seated. Thank you. Attorney Manning, should we wait for Attorney
If
McGinnis?
we can, Your Honor, he's just right outside.
Thank you.
Yeah, if you would, please. I thought I had it.
This morning is scheduled for what has been called the charge conference. Now, historically in the state of Connecticut, charge conferences in criminal matters were held in chambers. They were not public. There was no record. That is, there was no court reporter or court monitor recording the proceedings in chambers. A number of years ago, that changed, whereby charge conferences are now on the record. However, in this case, there has never been a charge conference in the state of Connecticut that has been live streamed. What the court will do first is just indicate how this conference will proceed. The court has given to each side its proposed jury instructions. Those instructions essentially are standard instructions from the Connecticut Judicial Branch Criminal Jury Instruction Manual. The parties have given to the court their proposed jury instructions. What the court does not intend to do is go through every jury instruction word by word and elicit comment. What the court first will do is ask counsel to comment on certain instructions. Then we will take a recess. Counsel will have a more full opportunity to review the court's proposed instructions, and then we will reconvene. So the first instructions that the court would like counsel to discuss are these: a consciousness of guilt instruction, a third-party culpability instruction, hindsight bias instruction, evidence of presumptive blood test instruction, and an instruction on motive. The revised version of what the court has given to counsel this morning includes instructions that were not heretofore included in the original draft, the first draft. That is, the court has included an instruction on accessory liability. The court has included an instruction on expert testimony, and the court has included an instruction on stipulation. Those instructions were not included in the original draft. So to begin, court would hear from counsel on an instruction which the court did not include in its draft, the instruction on consciousness of guilt. And the court would defer to Attorney McGinnis.
Yes, Your Honor. Good morning, and may it please the court. I think we had discussed counsel can sit down.
Yes.
Okay. All right. Yes, Your Honor. We are requesting the consciousness of guilt instruction, which is in the state's proposed instructions. It can be found on page 13, Your Honor, paragraph 6, or enumerated paragraph 6, I should say. And Your Honor, essentially, we're relying on State versus Pascal 109 Con App 55. 70 to 74. It's a 2008 case with respect to false statements that we allege were made by the defendant during the course of the interviews. The instruction itself is fairly standard, and I think we've sort of indicated to the jury that unless they find that the alleged fabrications and destruction of evidence was related to the act of the actual alleged charges, then they shouldn't be making a finding that it shows a consciousness of guilt. So we think it's written in a very balanced way. One of the issues that we take with the defendant's proposed instruction on consciousness of guilt is that it's essentially attempting to marshal the evidence, which seems to be something that is common in a lot of their requests, that they're asking the court to sort of marshal evidence for them and engage in closing arguments. So what we've done is simply identify the evidence which we believe demonstrates a consciousness of guilt, and we're asking the court to instruct them that unless they make certain findings, they shouldn't consider it as consciousness of guilt. But I think to go further and essentially get into a debate about what the defendant claims were the reasons, I think is a bridge too far for this particular instruction. So we would ask that the court adopt our proposed instruction.
Attorney Shonon.
Well, as Your Honor will note, in my Roman numeral 10, I indicated at the top that I didn't agree that in this particular case that consciousness of guilt should be given, and there are a couple of reasons. In this case, it's too confusing. If you read the consciousness of guilt in cases, it's either there's no question that there was conduct that was undisputed, whether it could infer the consciousness of guilt from it or not. Either it was flight, it was personally destroying something, it was statement trying to influence another witness, tell them to lie to the police or hide something or throw something away. There was no dispute as to what the conduct was. My concern, and the way if the court's going to give an instruction, is it's not clear from the evidence that anything was stated falsely, whether it was a mistake, whether it was actually accurate, whether she was fed information that was untrue and then adopted it and therefore sort of acknowledged or agreed with the officers that, and if Your Honor will remember in that third interview, when they asked her, if the question that is asked, I think by Detective Clabby is, was that a lie or was that a mistake? And her answer is, well, I wouldn't call it a lie. The state assumes that must mean it's a lie. So we have all of these problems, if you will, with whether or not there is even evidence that would constitute what I would call either interfering or obstructing evidence. The concept, a person runs away from the police, the person tells someone to lie, a person bribes somebody. All these are things that, if proven, nobody would dispute whether or not they were evidence of maybe a guilty conscience under that circumstance. My point being, and I think State versus Pugh, the case I cite, is the one where there's multiple interpretations of what the defendant in that case did, but it would be more like the concept, I think, in Pew, they talk about, well, flight. You know, if a bunch of people run away when the police show up, you know, let's say it's a drug case, that doesn't mean they're guilty of the drugs. It means they're just running away from the police, so it's ambiguous. So, you know, I wouldn't call it marshaling the evidence. I just believe this is not a clear-cut case where there are facts that if they find somebody said something that turns out to be false, that's consciousness of guilt, any more than when the court gives the instruction on credibility, people might forget things, you know, it doesn't mean that any witness who testified falsely because they may be inaccurate any more than we demonstrated that, you know, use this as an example, Detective Kimball admitted that some of the things he had previously sworn to turned out to be false. That doesn't mean you get a consciousness of his guilt instruction. So I'm just pointing out that it's not a clear-cut matter, and that's why if the court is going to give an instruction, it has to be more nuanced. There has to be more detail given to it, because otherwise the suggestion is, as the state has inferred throughout, oh, she lied. So that's why I'm asking that it not be given, because it's too difficult to really give that kind of instruction here without explaining all these other reasons why any testimony was not necessarily, any statement rather, was not knowingly inaccurate.
Again, because this is the first time that a charge conference has been live streamed, the court is going to take some pains to explain how it proceeds in a charge conference. The court is under no obligation to accept the proposed jury instructions of either party. What the court attempts to do in a charge conference is determine which instructions will be correct in law and find their basis in the evidence that was presented. And the court will also hear counsel on the court's next concern about a consciousness of guilt instruction. The boundaries of consciousness of guilt seem to this court to be somewhat amorphous. And the court does not want to try to firm up what seems to be amorphous boundaries, because the court puts itself in a position where it may sound like it is marshaling evidence in order to give those boundaries contour and definition. So the court is not inclined to give a consciousness of guilt instruction. However, the court believes that instructions on credibility and inconsistent statements will encompass the spirit of a consciousness of guilt instruction. The next concern the court has about an instruction it did not include in its original draft was a third-party culpability instruction. The court is concerned about that instruction because this was not a textbook third-party culpability defense. So the court will hear first from Attorney Shawn.
Thank you. I'm including this is because the way that the state charged in count one, it specifically states that did agree with Fotis Dulos and other persons. Now, I would argue that perhaps what the court would need to do is realize that the only evidence the state put on was that or attempted to show is that Fotis Dulos himself committed this crime essentially on his own, ignoring the evidence such as where was, let's say, Pavel Gumieni, what's going on with Kent Mawini, the fact that I think that it is now fully established that it's Jennifer Dulos's phone that connected by Bluetooth to the Suburban at 2:56 p.m. in the afternoon, when the state claims and agrees that Fotis Dulos was back in Hartford. So there's obviously other, in my view, at least the evidence shows, there's at least one other, maybe more people involved, but it wasn't Michelle Troconis. My concern is without this instruction, there are all these things that are happening that it couldn't be Fotis Dulos himself, whether it's Kent Mawhinney in the office, whether it's Andreas Toutsiardis in Greece. The evidence has indicated there are others that participated in a scheme, at least on its face, there's factual evidence with Mr. Dulos that did not involve Michelle Troconis. And that's the reason that I'm asking for that instruction. If the court were to remove from the order that the language from the instruction be stricken, that there were other persons, and I had asked for a bill of particulars, how do I defend against these unknown other persons? But if you remember before we started, I think it was Attorney Manning said on the record the other known conspirators were, and she named Mr. Gumieni, she named Mr. Mawhinney, and I believe, I can't recall if if she named Toutsiardis as well. She didn't call them co-conspirators. She used a different term, and I don't remember at the moment what it was, accomplices or evidence of accomplices, but it was during one of our online motions hearings. So the way I look at this, Your Honors, either the information has to remove other persons completely, and then it's all about just whether she conspired with Fotis Dulos.
Yes, Your Honor, we do object to that proposed instruction. Firstly, I'll just note that in order to get a third-party culpability instruction, the defense must raise more than bare suspicion, I believe is the language from our case law, or mere suspicion. And essentially asking questions like, where was this person? Where was that person? This could somehow generate reasonable doubt is nothing more than bare suspicion at this point. There's no direct evidence that anyone else participated in these crimes. It's all conjecture and speculation on the part of the defense that somehow a phone connection is conclusive proof that someone else was involved, when there was no technical evidence to that effect that they introduced. Could have just connected because it was in the woods nearby, for all we know. So I would object on those grounds because I don't think they've made that a sufficient showing. Also, Your Honor, with respect to the conspiracy count itself, we just need to prove that she conspired with one or more persons. And so whether or not other people were actually involved, so long as she conspired with Mr. Dulos, which we did plead, she would be guilty of conspiracy if the jury finds all the elements beyond a reasonable doubt. So I think it's not an appropriate request because they have not raised more than bare suspicion, and also the way it's charged in the conspiracy count, I don't think necessitates such an instruction.
Well, if I may just respond, then I noticed that Mr. McGinnis did not address the and other persons. So it is alleged that Michelle Troconis agreed with Fotis Dulos and other persons. So if the state is, by what I hear, acknowledging there is no evidence of other persons, and that language has to be removed from the information. Moreover, Detective Kimball testified that Kent Mawhinney was charged with conspiracy to commit murder in this case.
So if counsel has a case, I'm happy to look at it, but I haven't heard one.
Well, in this court's view, the third-party culpability instruction is not warranted by the evidence. Conspiracy to commit a crime with other unnamed co-conspirators, it appears under the defense's view, would always require a third-party culpability instruction. The court does not believe the law supports that proposition. Third-party culpability requires more than others were involved. It requires more than inferences raised on cross-examination that the defendant was not involved. So the court would decline to give a third-party culpability instruction. The next instruction, hindsight bias. Court will hear from counsel.
Yes, Your Honor. This is the thrust of the defense's defense. And I believe the Connecticut cases say that a defendant is always entitled to get an instruction from the court as to what the defendant claims. And hindsight bias is mostly in civil cases, but we cite at least one such case that talks about, often they're in malpractice cases or in other cases where the defense is, well, at the time they didn't know, and that's the thrust of our defense in this case.
Your Honor,
Yes.
so Attorney Manning had a chance to look at Professor Loftus's testimony when we received this instruction early this morning, and the word hindsight is not used at all. So I don't think that there's any source within the evidence for this instruction. I've never heard of this instruction. I don't want to make any misrepresentations to the court, but I thought I went to State versus Lewis this morning and did a control F for hindsight and didn't find the word. I could be mistaken on that, but in any event, Your Honor, I'm not aware of any case that stands for the proposition that this instruction as constituted is appropriate. Again, it's asking the court to marshal evidence and to essentially engage in closing argument through the jury instructions.
I may respond
Yes.
very briefly. That it's not just what Professor Loftus said. Several of the detectives indicated they asked the witnesses, in hindsight, did anything seem out of place? I asked similar questions to several of the witnesses, and they all said no. So if we're talking about what the jury is seeing in current time with everything marshaled by the state versus what was known at the time, that is the basis of our defense in the case. And the cases such as Canaan and Lewis, they don't talk about hindsight bias. They talk about the right to have the judge explain to the jury what the defendant's defense is, other than she didn't do it.
Obviously, he can argue that, Judge.
Well, the court's view is hindsight bias is, first of all, a term that is new to this court. Secondly, if the response, as the court remembers the testimony, was always looking back, there was nothing that would have been an indication as to certain activity. Well, then the fact that in the first instance, there was no indication, it would seem to be a tautology to say that in the second instance, also there was no indication. So the court is not inclined to give an instruction on hindsight bias. Evidence of presumptive blood tests, specifically the KM test.
Yes, if Your Honor will recall, the court, there was a lot of debate on that issue. The court read some cases, and then the court said the court would allow it in for a limited purpose to show why the police did what they did. Since then, there's been so much talk in the last several weeks about luminol and KM and presumptive testing that the court only needs to go back to State versus Moody, that specifically that case said it has no evidentiary value whatsoever, and the word whatsoever, I believe, is in the decision. So the purpose of this is to remind the jury that if evidence was not tested for blood, then it cannot assume or conclude that luminol or Kastle-Meyer testing was blood. It took, I think, until the scientist, I think her name is Anna Valonis, who finally admitted that these presumptive tests only indicate the possibility that blood is present. And until that point, they kept repeating likelihood or the likely presence, and then said, well, that just means it's possible. But I would rely on not just those facts, but Moody to make sure that the jury understands. And it's also to limit any misconception that the jury might find, that they would think that those KM and luminol testing were in fact evidence of blood when they're not.
Yes, Your Honor, we object to the proposed instruction. So again, this was probably the first week of trial or so. And so again, I don't want to misstate anything here, but our recollection, and we talked about this morning, wasn't that the court let it in for just the limited purpose of showing the actions that the police took. The court reviewed all the case law and said that KM testing in and of itself might not be relevant, but in the totality of all the evidence, it could be relevant to the case. And so that's our recollection, that the court wasn't letting it in for some sort of limited purpose, but and that's why the instruction as proposed is not appropriate in the first instance. But moreover, again, use of the term so-called, it's inherently unreliable. Again, they're asking the court to essentially marshal the evidence and engage in closing argument for them. What the gravamen of that evidence, Your Honor, is that all these presumptive blood tests, or not all of them, but the vast majority of them, subsequently tested positive to be a single female contributor that was consistent with the toothbrush. And so the idea that these have no reliability whatsoever, when we understand that there was a blood pattern expert that came in and testified consistently that this appeared to be blood, they end up being tested presumptively for blood, and they subsequently come back to be Jennifer Dulos's DNA, which is of course what we're going to argue to the jury. I don't recall the court handcuffing the state in terms of how that evidence could be used by the jury. And I would ask that the court not marshal the evidence for the defense. If they want to argue that on cross-examination, they pointed out through different witnesses, and my recollection is Detective Riley even admitted it's simply a presumptive test. The lab referred to it as a screening test. If they want to argue that this wasn't blood, or there's no proof that it's blood, they can make that argument, I suppose. But I think it's fair for us to make the alternative argument, which is that it's presumptive blood test, comes back to Jennifer Dulos repeatedly, and it looks like blood. So
That's exactly what I believe Moody said that could not be done. The fact that there was some DNA, it was just as likely it was skin. There was no, the only confirmatory tests that were done were on 2 items of clothing and 1 other item that I don't recall at the moment sitting here what it was. That would be an improper inference that this was all blood. And that is why the Supreme Court, the case that the exception was that an expert assumed it was blood for purposes of that expert's testimony. In that one case that Your Honor was cited and mentioned as why it would be allowed in, but it was to indicate why the police did certain things. For the state to argue that they can infer that because the DNA was found, that meant it was Jennifer Dulos's blood, would be not only confusing, it would be a false inference, and I would submit would be particularly prejudicial under the circumstances.
Well, the court's recollection of the evidence is that the cross-examination was sufficiently strong concerning presumptive tests, screening tests. The lab expert's testimony concerning presumptive tests, well, the lab does not use the term presumptive, but screening. So the court thinks that there's no confusion that the jury would suffer if there was no instruction on presumptive blood tests. So the court declines to give that instruction. Finally, the instruction on motive. Attorney McGinnis.
yes, Your Honor. This is from the pattern instructions. We did put forth through the defendant's own words, Your Honor, evidence of motive, specifically not only her police interviews where she referred to the last 2 years of her life being 2 years of torture, but also the fact that she referred to Jennifer Dulos in disparaging terms, which I'm not going to repeat right now. The fact that she was disappointed over the ongoing custody dispute, the fact that she was going to be potentially moving to Colorado as early as June 10th, according to her own words. We believe that there is a sufficient record for the court to give an instruction on motive. And again, I just took this from the pattern instructions and inserted a brief statement where the pattern instructions told me to. If the court doesn't wish to include the brief statement of facts because it would be, doesn't want to be even the chance that it be perceived as marshaling the evidence, I'd have no objection to that being removed. But I do think that there's a sufficient factual basis for them to at least get an instruction on motive. And I would add also that the instruction itself, as it comes from the pattern instructions, is a balanced instruction. So in other words, if the jury chooses to reject the state's contention of motive, that could be evidence, I guess, of the fact that the defendant didn't commit the crime. So it's written very balanced.
Attorney Schoenhorn.
Well, two things. First of all, I would question this idea of balance. It said, first of all, the state argues if no motive can be inferred, it may or may not raise a reasonable doubt. I believe that the language, the proper language is if there's no motive, it might in fact raise a reasonable doubt. But so when I hear balance, that's certainly not the way it's written. Your Honor, with regard to the fact that the state is saying that because the divorce was negatively impacting her relationship and therefore she's going to murder her boyfriend's wife. Just if that is considered motive, then I guess moving to Colorado would need to be included in there. The fact that there was a light at the end of the tunnel, that everyone who knew anything about what was going on in the court was saying that things were favorable for Fotis, all of that would need to be in there. I would ask that the court not give this instruction, and certainly not in the one-sided suggestion, which is, particularly tenuous anyway. She doesn't like that there is her relationship is being negatively impacted and the quality of her life. Nowhere is there evidence of that. She did say that the dragging on was I think in the language of the interrogation, I think she did say it was like torture, but the other evidence shows that it was ending. Everyone was happy. They were talking about it. She was aware of the contents. So I think it's too prejudicial. Well, never mind, prejudicial. It's too vague and one-sided for the court to give that instruction.
Judge, I just want to add that I've prosecuted cases where people have murdered for far less than the motive that we've presented in this case.
The court is inclined to give an instruction on motive. The court will fashion the instruction such that it does not marshal evidence on behalf of the state. Those were the primary concerns of the court. Now, the court will indicate that because there are conspiracy counts, the court, in trying to make the instructions as clear as possible to the jury, wove the substantive counts into some of the conspiracy and accessorial instructions. So when we return, the court will hear counsel on the substantive charges. The court's main concern is to make those charges, the instructions to the jury, clear. Because
I'm sorry, I didn't mean to interrupt.
Because by themselves, the instructions may confuse the jury if the court did not, in this court view, weave in the substantive counts with the explanations of accessorial liability and conspiratorial liability.
Would the court at this point entertain at least some of the things that stood out that the court may want to consider before it comes back out?
On
the
substantive counts?
No, on the second draft, or on some of the more general.
Do they concern instructions that the court did not include?
No, it's including instructions that the court included, which I don't think the court should include.
Well, that's the different discussion that should come up after we come back from break.
Okay.
So the court wants to give counsel an opportunity to review the revised instructions. Let's return at 11:30.
All rise.
Please be seated, thank you. Have council had the opportunity to just review what the court will refer to as its second draft?
Yes, Judge.
Okay, thank you.
I will note, Your Honor, that the only parts I did not get a chance to review yet, but there are ones that I would assume are standard on note-taking, sympathy, and duties upon retiring. So assuming that those are standardized, those are the ones I didn't get a chance to look at before you just came back on the record.
Those are standard, Attorney General. Okay. So this is how the court intends to proceed. The court is going to, from its second draft, just first indicate the topic and then ask counsel if they have material revisions that they would like the court to consider. The court is not inclined to entertain, unless it affects materiality, syntax. But again, if it affects materiality, the court will consider it, and style.
Does that include, so for example, there are a couple of prepositions missing, an article?
Oh, that's that grammatical errors. We can take that up.
I was going to say you'd want us to at least bring that to
Yes.
your attention. Okay.
So, court is not certain that, well, we'll start at page 1, the function of the court and jury. It's material, court will consider it.
I have nothing, Judge.
Nothing from the defense.
Thank you. Presumption of innocence.
I have nothing, Judge.
Nothing from the defense.
Burden of proof.
Nothing.
Nothing, Judge.
Reasonable doubt.
Nothing, Judge.
Nothing.
Intent, general and specific. Now, the second draft includes language at the end of this instruction that all of the crimes charged in this case are specific intent crimes.
So we would ask, the defense would ask that you remove then the definition of, well, 2 places on page 8, the fact that the court, that the law recognizes 2 types of intent, general and specific. Since there's only specific, that sentence should come out in the next paragraph, which defines general intent should come out.
Attorney Schoenhorn? Attorney McGinnis?
If I could just have one moment, Judge. Well, I would ask that the court keep it in, because although these are specific intent crimes, there are elements that have sort of a general intent. So for example, tampering with physical evidence, even though the intent has to be, to sort of make the evidence unavailable for a proceeding, there is a general intent piece to it also, to tamper with physical evidence. You don't need to have the specific intent to complete every element of the crime. You just have to have the specific intent for a particular consequence. So I would ask the court leave in the general intent.
That's an incorrect statement of the law. I think it's either 53A- either 4 or 5 states that if there's a specific intent, or if there's a mental state indicated in a criminal statute, then it has to apply to each and every element.
So what the court will do in this instance is strike the second sentence on page 8, the law requires 2 types, and strike the second paragraph concerning general intent.
And then I would, my further request, Your Honor, is on page 9, is when the court does say what the defendant intended is a question of fact for you to determine. And I added that, like all other elements, must be proved beyond a reasonable doubt.
I don't have an objection to that request.
Okay. Page 10, evidence of intent.
I have nothing.
Your Honor, I think the bottom paragraph there refers to general intent in there, and therefore, once we've taken that out, that whole first sentence there, I would think needs to be revised because it talks about meets the standard it has to meet. So I think that was either general or specific intent. So my suggestion was, as jurors, you may draw reasonable inferences as long as the inferences meet the standard of the definition of intent.
Well, this is evidence of intent.
Right, but I'm talking about the last, I think the way it's written, it talks about meets the standard it has to meet. Well,
As explained with the instruction on, which we haven't reached yet, on circumstantial evidence.
oh, I see. It refers to an instruction you haven't given yet. I get it. Okay.
And then direct and circumstantial evidence.
The only thing I noticed, Your Honor, is in the second to last sentence on page 12, there should be a period after the word evidence and the next letter, if,
Yes,
is at capital.
thank you.
I have nothing, Judge.
On page 13, this is just for the record, the court indicates down towards the bottom that the state does not have to prove the exact location of the offense, but consistent with my argument about vicinage and the constitutional right to be tried where the crime is alleged to have occurred, I would object to the use of the word location. I certainly agree that the state does not have to prove the exact time and date.
Thank you. The court will leave that instruction intact.
Oh, I'm sorry. And Attorney Felsen pointed out in the previous sentence, where it also mentions location, it says of the offense. It should say each offense, since the locations are different in several of the counts.
So which sentence is that?
The one that begins, as you will see.
Okay. Each count and the information contains the date and location of the offense.
Oh. I'm sorry, I'm gonna, I realize the word each appears twice, but it would distinguish between certain counts take place at the same alleged date and time and others at a different date and time. And that's why I would ask that the word each instead of the offense be substituted.
So the court is not following the proposal. Are you talking about the last sentence on page 13?
No, the third to last sentence, the one that begins, as you will see.
So the
Each
court,
count,
yes, each count in the information contains the date and location of
each offense.
each offense.
Yeah.
Thank you. Credibility.
I have nothing, Judge.
Nothing from the defense.
Right not to testify.
Nothing from the defense.
Nothing from the state.
Impeachment, inconsistent statements.
Nothing from the defense.
Nothing from the state.
Police testimony.
Nothing.
Nothing.
Now, the court included an instruction on expert testimony this morning. Expert testimony.
Judge, the only input that we had, because we used the pattern instruction for our request, was to add the names of the experts in accordance with the pattern instruction, but
What the court thought about that, and the court thought that the court would do that. Some jurors may not consider some of those individuals experts.
sure.
So in this court's view, it's safer to keep it blank and let the jury determine who were experts in their view.
Sure. Other than that, I have no input on that instruction.
Also, the court did not recall all of the names. of
We
all of
we
those.
included them, but I understand the court's position on that.
Stipulations.
Nothing.
Nothing, Judge.
Identification of the defendant
Nothing, Judge.
Nothing.
and witness testifying under immunity.
We did put forward a proposed instruction on this, Your Honor. Now, I had a chance to attempt to research this issue on Thursday or Friday evening, whenever the court gave us its proposed instructions, and I couldn't find anything in the pattern instructions that was specific to an immunity grant. And so what we did was we essentially culled from a similar instruction. I believe it was the if I'm not mistaken, it was the jailhouse informant instruction, Your Honor. And I think defense counsel may have actually done the same as I was looking at their proposal. Our concern, Your Honor, with the current construct of the court's instruction with respect to immunity is that it does not balance out the other side of things in the same way that the jailhouse informant instruction does. So, for example, just with respect to the jailhouse informant instruction, there's several bullet points that gives the jury some guidance on things that they can consider when determining whether or not Pavel Gumini, was credible or not. Also, the way the court has phrased immunity, a witness's testimony may not be used against him in any subsequent criminal proceeding. He was actually granted transactional immunity, and so he just simply can't be prosecuted. It's not just a matter of, so I would ask that the court adopt our proposed instruction number 9, which is essentially borrowed from the pattern instructions rule 2.5-3. And we think it appropriately balances the interests of the state and the defendant when evaluating Mr. Gumini's testimony.
May I just have a moment to look at his instruction? I certainly agree. This is transactional immunity, which is highly unusual. So I had added a sentence, he will not be charged with any crime related to criminal conduct in this case. So, and it wasn't just whether he testified under a grant of immunity, it's the whole thing.
So the court
Let me just
will,
look at their language because it's rather lengthy here. There is a lot to favor what the state is saying here. I will note there's a typo, looks like in the second paragraph where the word, the second line in the second paragraph where it says favorable treatment, it says in the when, so I assume the in and the should come out of his proposal. There's also a reference here as to any other case in which the witness testified or offered statements. That bullet point should come out because there's no evidence that Mr. Gumieni testified or offered to testify in any other case, at least to my knowledge. I don't have any problem with that as long as the court uses its language that was in the second paragraph of its proposal that begins with some people in this position are entirely truthful, but you should consider the testimony with particular caution. That language, if the court, but I don't have any problem with incorporating the rest of it. It's a little lengthy, but it does sort of more accurately set forth what transactional immunity is and how it applies here. So I'm not objecting to all those bullet point suggestions. The only other comment, though, is it's in your proposal, you say he may have had reason to make up stories or exaggerate what others did. I would add or said, because if you recall that as it applies to Mr. Troconis, it comes down to what he claims she said on 2 occasions. But other than that, no objection to adopting most, if not all, of the state's proposal.
So what the court intends to do here is adopt the state's proposal for witness immunity. That's on page 9 of the state's charge, proposed charge, correct?
16.
Number 9.
Number 9.
Number 9,
Yes, sir.
page 16.
Thank you. Now, concerning the conspiracy to commit murder count, again, this is going to be, in this court view, a little bit more difficult to make clear to the jury. If the court were just to talk about a murder instruction without talking about at the same time conspiracy, that is in the same instruction, it becomes confusing. So the court will hear from counsel.
Judge, in our proposed instruction number 2, I think, so I agree with the court. I think there's a balance of efficiency while also providing the jury with enough information so that they understand exactly what the elements of each offense are. And here you have a situation where essentially the same crime is charged in 4 different counts. 2 is a conspiracy, 2 is an accessory when we speak about the tampering. And then of course there's the conspiracy murder and then the hindering prosecution. So what we proposed essentially, Your Honor, was that the court in our second proposal, read the information and then talk about the fact that before that you would instruct the jury on what conspiracy is, you need to understand the elements of murder. And then we lay out essentially that the state has to prove beyond a reasonable doubt that Fotis Dulos specifically intended to cause the death of Jennifer Dulos and that he did in fact cause her death, because we have alleged that as the overt act. We did include, Your Honor, additional language, which I took from State versus Richards as well as State versus Sivry. This is a unique case, Your Honor, in that no body has ever been recovered. I shouldn't say unique. It's not like it's never happened, but it's certainly a first for these prosecutors. And so in doing research on this issue, Your Honor, I pulled from Richards and Sivry, where basically, specifically with respect to causation, that the state does not need to produce evidence of Jennifer Dulos' body for you to find that she's deceased. You're only required to prove that Jennifer Dulos is dead and her death was by criminal means. Proof of the exact cause of death is not required, nor does the state have to connect a weapon directly to Fotis Dulos and the crime. In determining whether or not the state has proven Fotis Dulos caused the death of Jennifer Dulos beyond a reasonable doubt, you may consider both direct and circumstantial evidence. I refer you back to my previous instructions as to both types of evidence. So we are asking that the court add that under causation, and I rely on Richards and Sivry for those propositions, Your Honor. They're essentially borrowed from those cases. But then we get into the conspiracy to commit murder, and we sort of succinctly lay out the agreement, the conspiracy, the overt act, the criminal intent, and then a conclusion. So I think kind of, because the concern I have right now, Your Honor, is that having murder sort of separate and indicating the defendant had the intent to cause the death of another person. So it's true that she did have to have the intent to commit murder when she entered into the agreement, and we have to prove that beyond a reasonable doubt. But she wasn't there for the, sure. But she was not present for the actual act of murder, and so I don't want the jury to conflate those concepts. It's Fotis Dulos that would have had to have the intent to commit murder in the moment. The defendant, as part of the agreement, would have had to have the intent to commit murder pursuant to the conspiracy charge. But I just don't want the jury to conflate those concepts. And so essentially, we're acknowledging, yes, we have to prove Fotis Dulos murdered Jennifer Dulos. And as part of that, the defendant conspired to do so. So we would ask that the court adopt our proposed instruction. Let me just see if there was anything else. I think, Your Honor, the language of it is not necessary for a conviction for murder that the state proved the defendant intended to kill the person whom he did in fact kill. Under the facts of this case, it's probably superfluous because certainly no one's claiming that Jennifer Dulos wasn't the intended target or anything like that. And so we could probably remove that language. And then the court said, please refer to instructions on proximate cause, but I don't think we have any. So perhaps we should add those. I actually had a note to, I have had courts in the past, Your Honor, that haven't done so in shootings and things of that nature where it's so obvious what the cause of death was. But given the contested nature of whether or not Jennifer Dulos is deceased at some points during the trial, it might be appropriate to add the proximate cause instruction.
Where should I begin? First of all, I disagree that, the problem with approximate cause instructions, there has to be some underlying facts that would necessarily lead to that, and everything remains a mystery in that, and that's will be confusing in and of itself. In my view, the simplest way to clarify before Your Honor jumps to defining murder, have a preliminary paragraph saying that the defendant in the first count is charged with a conspiracy to commit murder. But before I define what a conspiracy is, I should tell you what you would need to find to prove murder, the definition of murder under Connecticut law, since you're going to have to find that as part of it and then go into the instruction. Rather than the problem I see with the way the state proposed its instruction, it doesn't even, I didn't even hear that the crime had to be intent to kill, that there was an intention to cause the death of Jennifer Dulos, and in fact, her death resulted, which are the actual elements. So I would object to their proposal. But if the court were to have like just sort of a introductory paragraph before defining conspiracy to commit murder, I should explain to you the elements of murder. From there, the court can then go to what is a conspiracy, as it does in the order that when we get to page 32, that's where the definition of conspiracy is. I agree with Mr. McGinnis that the way the criminal information is charged, it is to, it says assault Jennifer Dulos with the intent to restrain and kill her. Part of the problem is they've charged it that way. I think the court needs to put it in that way. And if they have failed to present evidence of it, that's their problem. But that's how they've charged it, that Fotis Dulos assaulted Jennifer Farber Dulos in her home with the intent to restrain and kill her. And I believe that the court necessarily has to charge the manner in which the state alleged.
So Judge, I know it's been a long trial, but I have that exact paragraph, and then I go through the elements of including intent to cause death and cause the death. So I don't know what he's reading, but In any event, Judge, obviously, I agree with him because I wrote it, that the court should include that introductory paragraph and then go into the specific elements. I also included in the to wit, Fotis Dulos did assault Jennifer Farber Dulos in her home on the 24th of May with the intent to restrain and kill her. So I'm not really sure what he's reading because everything that he just asked for is already in my proposed instruction.
Well, A, I'm not done. B, I'm reading from the actual criminal, the information that's been filed in the case. I was comparing it to your honors instruction, not to what Mr. McGinnis was proposing. The other thing about when we get to now on page 29, there's a whole paragraph in here on the number of wounds, the type of instrument used. I don't believe that should be in here since there's no evidence of what kind of instrument or the number of wounds. And so that would be, in my view, confusing and shouldn't be in here in this case. And I did agree with Mr. McGinnis that it can't be the killing of a person as opposed to the person. I think the way it's charged, it would require that it be Jennifer Farber Dulos. So I agree with Mr. McGinnis as to that.
Judge, just on that last point, there is evidence that there was at least 2 blows in this case. So I think it is appropriate to indicate the number of so-called wounds, if you will.
Let's be clear, Your Honor. The suggestion by the blood pattern expert was that there may be 2 based on his or more. That was not a conclusive fact, and therefore, and that is not a wound in any event that may be indicative of either 2 blows or, as I think the evidence showed, 2 places where her head hit the pavement. But in any event, your instruction talks about instruments of weaponry and number of wounds, not the whether there was 1 or 2 or more places where blood came out. And to be graphic,
Is there no inference that the jury can draw from the mop handle?
I'm sorry, Your Honor, about the
Is there no inference that the jury can draw from evidence of the mop handle recovered in the trash?
The mop handle?
Or broom handle?
I think what the court's getting at is that there was a mop handle which was introduced to evidence which was broken and that there was blood on the end of it, or at least substance consistent with blood that tested positive for Jennifer Dulos' DNA.
Up until this point, it was my understanding that the mop handle was claimed to be something that was used to clean up at 80 Mountain Spring Road, but there's no evidence that that mop was in New Canaan.
Well, the evidence was that it was in the trash. It was disposed of. And there's evidence that there was blood on the handle. So the jury can draw an inference that it was used. They don't have to draw that inference. They could. So as far as the number of wounds inflicted as well as the instrument used, there's enough evidence there for the jury to conclude that a weapon was used. What the court wants to, what the court is going to do is probably read the state's instruction again and substitute. Well, first the court would want to know this. Would it be clearer if the court begins with the sentence with which it begins? The defendant is charged in count 1 with conspiracy to commit murder. The court must first explain the statute defining murder. In a later instruction, the court will explain the statute defining conspiracy. The defendant has not been charged with murder, but with the offense of conspiracy to commit murder. Is it appropriate at that point to discuss the charge for murder or conspiracy?
So the way I propose to judge is that at that point, I write, before I instruct you on what conspiracy is, I will read you the elements of murder. So I have no objection to the court proceeding in that manner.
We agree.
Now, again, what the court's inclination is at this point, and again, the court is going to have these revisions done before the end of the day. At least that's the court's plan. And of course, after argument tomorrow, counsel can object to any of the instructions that the court had given. Now, on the conspiracy charge.
Your Honor, there is one other point. It's similar to what was said on page, to be consistent, on page 31. We talk about the death of one of the actions of one of the co-conspirators. I think there it should be clear that we're talking about Fotis Dulos as is alleged, and I think it's not any one of the co-conspirators. It's the fact at the top of page 31 that she died as a result of the actions of Fotis Dulos, not some unnamed co-conspirator.
I don't
Well,
have an objection to that because we're not going to be taking a position in front of the jury that it was some mystery man that was part of this.
well, if the court adopts the state's proposed instructions, the court's instructions as they are drafted now will not be the instructions.
Oh, okay.
The conspiracy count instruction.
Yes, Judge. I propose, this is proposal number 3. I combined counts 2 and 4 since they are the exact same charge, conspiracy to commit tampering with physical evidence. The one request I would make of the court, Your Honor, is that in our proposal, we have the court reading the information as it relates to each count. And the reason is because there are multiple charges of conspiracy to commit tampering with evidence. There are multiple charges of accessory tampering with evidence. And so I just want the jury to understand exactly what each count is and what it applies to. So our initial proposal, Your Honor, is that the court would read the informations as to count 2 and 4. And then if you go to page 7, at that point, you would define the definition of tampering with physical evidence similar to how you define murder. And then after you're done defining that, essentially you would, beginning on page 8, recap conspiracy. And I have certain language with respect to the first 2 elements of conspiracy to commit tampering with physical evidence. I refer you back to my previous instructions from count 1 on the definitions as to what constitutes an agreement and overt act and furtherance of the conspiracy. And then go on to say the third element of counts 2 and 4 is that the defendant had the intent to commit tampering with physical evidence. My bigger concern, Judge, with the tampering was that in the third element, Your Honor, so we allege the third element is that the defendant specifically intended to impair the validity or availability of such evidence, but the court has the third element as producing something false in court. I think that there's different ways to commit the tampering
Which
charge.
page is that on, Attorney McGinn?
In your instructions?
Yes.
Just give me one moment. 45, Judge. And 46. So we're not alleging she specifically intended to mislead and deceive the public servant holding the official proceeding. We're alleging that she was attempting to impair evidence from being available.
So number 3,
Yes, sir.
and what is the proposal?
So how we've proposed it, Your Honor, is that the third element is intent to deceive. The third element is that such person altered or destroyed or concealed or removed any record, document, or item with the purpose of impairing its validity or availability in such proceeding. Such person must have acted with the specific purpose or intent of impairing the validity or availability of the evidence.
And what number is that? Which number of the instruction?
I'm sorry, when you say which number?
Instruction number, proposed
Oh,
instruction
our
number.
proposal is number 3. Our proposal can be found on page 7, Your Honor, of ours, and it is proposal number 3, which goes from page 6 to 9.
You wish to be heard, Attorney Troconis?
Yes, first of all, we're now jumping around here to tampering when we're still on the elements of conspiracy. I have presented my proposal 14, which begins on page 7, goes into each of the elements of a conspiracy, and I thought that's where we were. Now we're jumping to conspiracy to commit tampering.
Well, let's continue with conspiracy. The elements of conspiracy.
Right. And again, my proposal 14, which goes into some extent, but I'm just noting if to the extent that the court is looking at its version on page 33, there's this on the right above the word the elements, it says participation in a single act and furtherance of the conspiracy is enough, but it had to find a knowing participation. But I think it should be that knowing participation in a single act and furtherance of the conspiracy is enough to sustain this element. But it may be just semantics, and so I'll just note it to, if it sounds clearer. That was my suggestion with regard to that.
I think the court, the members need to specifically find that she intended to engage in the agreement. So I think adding the word knowing at that point is superfluous, because obviously if they find that she specifically intended to agree to commit the crime and a co-conspirator committed an overt act, then essentially that's all they would, those are the only findings that they need to make. It's essentially be adding additional mens rea.
But I believe there are two mens rea. You have to knowingly participate and knowingly or intentionally intend to commit the underlying crime. It's a dual intent requirement.
The court will take those considerations under advisement.
And then on page 35, it's again, when the court talks about joining with at least one person, it's knowing and willfully joining, because, you know, the evidence shows she's certainly present, but it would have to be specifically knowing for that purpose. And that's why I throw in those extra words. But as I said, I set that forth in my proposal, but
it appears clear from the court's instruction that joining means knowingly joining. That's how it appears to the court.
So I mean, in my proposal, Your Honor, I essentially used the pattern instructions with respect to conspiracy. And so I would ask that the court adopt our proposal on what the definition of conspiracy is, beginning at page 3 of our proposal through 5.
Well, this instruction is taken from the judicial branch criminal jury instructions. This is standard. So the
and then I
court
note, Your Honor, on page 35 down towards the bottom, since the bottom part talks about murder, when you talk about the charge containing the information, I think you probably should have in the first count of the information, because that's where reference is made to murder. The next sentence, I'm going to top the next page. And then on page 37, I'll wait till Your Honor's ready. I don't know if Your Honor's ready.
the court's ready.
In the top paragraph that begins the third element, the next sentence, it says, this means that the defendant must specifically intend that every element of the plan, again, since there's more than one charge, and we're talking here about, at least in this first instance of talking about conspiracy, it should be that specific crime rather than the word plan, to make it clear that we're which element we're talking about, or which charge.
So the language should be, this means that the defendant must specifically intend that every element of the crime.
Specific crime of the crime be accomplished.
I think that the pattern instruction has it as planned offense.
But there's probably
Planned offense.
I think that's the pattern instruction, how they word it.
All right. Well, that would be fine too. I'm just noting that since they've charged it more than one count, they can't say, well, we'll just, if they agree to this, then we'll just assume it also applies to that. Then on page 38, this is just, my concern is, it says that if the state fails to prove beyond a reasonable doubt at least one element, I think it's any one element rather than at least one, suggesting that they should have to maybe consider more than one. Once they find one isn't proven, that's as far as they need to go. One element.
Yeah, so I specifically indicated, on the other hand, if you unanimously find the state has failed to prove beyond a reasonable doubt any of the elements, you shall then find the defendant not guilty.
But
So
any of the elements is more confusing in this court's view. It means any means all.
Okay, any one is what we're saying.
It's clearer if the language is any one.
I have no objection to that being added, Your Honor.
And Your Honor has next on page 39, accessorial liability. In my view, and I don't know if the state agrees, the underlying offense for which accessorial liability is alleged should come before we talk about an alternative means of committing an offense. Having it here by itself without the elements of the crime, which this applies to the tampering.
So in other words, please refer to the court's instructions on counts 2 and 4, or
I think-
what is trying.
Well, are you finished, John?
There are other issues in here. The court is reading the entire accessorial statute 53A-8, but the state only charged some of the means. They did not allege soliciting, requesting, commanding, or importuning. And therefore, the court is expanding the nature of the charge, for which I submit there is no evidence anyway, but I believe that the purpose of the information is to narrow the scope of what the jury has to determine.
Well, that's not really accurate, Your Honor, because what we did was we charged the substantive offense and put the defense on notice that we would be pursuing a theory of accessorial liability through the statute. So it's not true that we limited ourselves at all by charging it this way. So I think that the court, by including all the language appropriately, covers the charge, which includes alternative ways to commit the offense.
Well, I guess the question then is, where in the evidence can the state point to that the defendant solicited, requested, commanded, or importuned Fotis Dulos to commit a crime?
Well, the law indicates that if we're charging in the conjunctive, it all means or.
Right, but those words are not in the information at all.
But those words are, well, the court has included that language in the instruction, that the state need not prove all 5. That is, requests, commands, importunes, aids.
Well,
Or to say all
aids, we
4.
would agree that intentionally aids would certainly be,
And the jury does not have to be unanimous on any one of the ways. So the court does not see the request that the court excise, solicits, requests, commands as fatal to the instruction. It's just the standard instruction.
One area, though, that I do agree with Mr. Schoenhorn is I would ask, Your Honor, and this is our proposal number 4, which is found on beginning on page 9, that the accessorial liability be applied surgically to just the counts that it applies to. So in other words, the court introduces the concept of counts 3 and 5. And then if you go to page 10 of our proposal, you sort of just very briefly rehash the elements of tampering with physical evidence, and then you explain accessorial liability with respect to counts 3 and 5. And, you know, we specifically allege Fotis Dulos committed the underlying crimes, however, et cetera.
Court will consider that proposal.
And then I'll just note on page 40, where the court begins the second paragraph, if the defendant did any of these things, nowhere does it state, and I believe it should state, if the state can prove beyond a reasonable doubt that the defendant did any of these things, she is guilty of the substantive crime. But the way it's written, Your Honor, it doesn't apply to the rest of the elements. So that's why, and again, I think Mr. McGinnis, I agree that maybe the specific counts should be set forth first, and then there's this alternative means of committing by aiding and abetting under 53A-8. But it doesn't say that that becomes, they have to prove that if it's even if it's accessorial liability, that has to be proved beyond a reasonable doubt.
Well, what the court may do is just get rid of at least the first 2 sentences of this first full paragraph on page 40.
And Judge, just briefly, those are the language from the pattern instructions, because obviously if they find that she did any of these things, then she is guilty of the substantive offense. I do agree with the defense, though, that we do need to prove that beyond a reasonable doubt. So if the court wanted to just simply add the language, if you find beyond a reasonable doubt that the defendant did any of these things as specified in the statute, then I think that would accommodate or at least alleviate their concern and allow the court to essentially leave the instruction as is.
So what the court will do, the first full paragraph, the court will just insert the language after if the state proves beyond a reasonable doubt that the defendant did any of these things. That should remedy the concern.
I agree.
Anything else concerning accessorial liability?
On page 41, the first sentence, it says defendant to be found as an accessory. I assume it's just you're missing the word guilty.
Yes.
And then there's, and again, the
Concern
next
about,
sentence, I don't know if there's just words missing. It says state that the mental state necessary to commit tampering. I think you perhaps meant to say the mental state necessary to commit the crime of tampering with physical evidence.
thank you.
And then I note in the next paragraph, inactive is 1 word instead of 2.
What page are we on?
41.
41. Thank you.
And I'll just note that the court has indicated it's going to read all those, the solicit request, et cetera. I just maintain my exception as previously noted without repeating any of that.
Thank you. Now, shall we move on to tampering with physical evidence?
Yes, Your Honor.
Yes.
The one thing I would note, Your Honor, is
1 second.
Okay.
the state in count three and 5 and arguably also the conspiracy counts as well, conspiracy to commit tampering, is limiting its claim to a thing, not a record or document. So I'm asking that the court remove those words from the instruction on what it is that was altered, destroyed, concealed, or removed in a couple of places, because they've limited it to the word thing, which is in the statute, but these other items, there's no evidence that she tampered with a record or document, or even aided in the tampering of a record or document.
So which page are we on?
44
Thank you.
in the quoting from the statute, the relevant portion.
Yeah, we're not claiming that there were any documents or records that were removed, so we don't have an objection to that request.
And I also noted there's a preposition at the very top of that page, Your Honor. It's the defendant's charged with tampering.
Thank you.
On page 45 in the middle paragraph there's reference to fabricating evidence. I don't think there's any evidence that she fabricated. That goes for if somebody creates a fake affidavit or, fake evidence and offers it for purposes of proceeding. So I would ask that that be removed. And in that same paragraph, the words document and record are in there as well, in the same thing. They should just come out of that paragraph. And then on page 46.
Well, let's stay on 45 for a moment.
All right.
The first full paragraph. Is that the paragraph to which you referred?
No, the second paragraph where the word fabricated appears in the second, it says the second element is.
Yes, that's the paragraph. The second element is that the defendant tampered with or fabricated physical evidence.
Right, as opposed to tampered with. So it's the word fabricated is I think that's in the statute.
We're not claiming fabrication, we're claiming tampered with.
Thank you.
And then on the next line, it's those same words, document and record. And I have no objection, the words article, object, or other item is certainly, consistent with a thing. So, but I think document and record.
So for the first, when the court says the first full paragraph, it's the paragraph that begins the second element.
Mm-hmm.
Yes.
Is that the defendant tampered with physical evidence? Is that what?
Yes.
Yes.
Thank you. And the second full paragraph, which begins with the third element, that the defendant made or presented for use any item?
Item, not record and document, right?
Thank you.
So it would be, means physical evidence means any article, object, or other item of physical substance.
Yeah. Mm-hmm.
So again, the third element is that the defendant made or presented for use any item. You're saying physical item?
Oh, I'm sorry, Judge. I misunderstood. I was still on paragraph 2. The third element, Your Honor, is the element I was raising with the court earlier before we redirected back to conspiracy. So we have in our proposal at the bottom of page 7, element 3 of tampering with physical evidence, intent to deceive. The third element is that such person altered or destroyed or concealed or removed any item with the purpose of impairing its validity or availability in such proceeding. Such person must have acted with the specific purpose or intent of impairing the validity or availability of the evidence. A person acts with the intent when their conscious objective is to cause such result.
And in my proposal, Your Honor, 16 on page 9, I took out the word verity only because it's kind of an arcane term, and I'm not sure the jury will know what that means, but I agree that it should be the impairing its availability as evidence. I just took out the word verity in my proposal because.
So where did the court address this issue in its instructions?
So I think the court, so there's different ways you can either tamper with physical evidence by either concealing evidence, as we allege in this case, destroying it, or alternatively fabricating evidence in an official proceeding. And we've alleged the former, but not the latter, but it appears the court has inserted the element for the fabricating evidence in an official proceeding.
So again, let's go over in the court's instructions, page 45, the second element is that the defendant tampered with physical evidence. So is the suggestion that the definition of physical evidence should not include document and record?
Correct.
And should not include article?
You can stay in. An article is a thing, so I have no objection to that.
Object.
Can stay in.
And on page 46, there's no claim for fabricated, correct?
There is no claim of fabricating, so in element number 3, specifically intended to mislead and deceive the public servant holding the official proceeding, that's not,
I think on page 46, it's the word fabricated should come out under number 2 in the middle paragraph.
Right,
there.
and number 3,
so, well, so in our proposal, it's page 7 at the bottom, Your Honor, of our proposal, element number 3.
okay. Thank you.
Obviously, you're moving with record and document as we just talked about,
Thank
but
you.
otherwise we'd ask the court to adopt that.
Thank you. Hindering prosecution.
Oh, Your Honor, before we move to that, Attorney Felsen noted in the last sentence on page 47, first of all, state is misspelled.
Yes,
And then again, here's that language, at least one of the elements, when you were going to
Yes.
change it, I think, to be unreasonable about any one of the elements.
yes. Thank you.
And I have on, nothing on page 48, but on page 49, and I'll indicate, I did provide the court in number 17 of my proposals on page 10 and 11. My proposal, but I note that the state's information only alleges transportation. If Your Honor will recall, this was the subject, Your Honor raised a question about on the judgment of acquittal about what is the nature of the allegation. They only alleged transportation or other means. They did not suggest that my client provided money, weapons, or any disguise. So I'm suggesting that should.
Wasn't the evidence about the haircut disguise evidence?
Judge, we're not alleging that as part of this particular count. This count, Your Honor, count 6 relates to what happened at Russell Speeder's car wash on the 29th. And of course, the haircut would have occurred in advance. I don't have an objection in our proposal, Your Honor, which is number 5, begins at page 11. I took out some of the language, as counsel just indicated, which we're not alleging. Obviously, we are alleging transportation and other means. However, we're not alleging money, weapons, disguise. In your proposals, you're on page 49, the second and third bullet points don't appear to be applicable based on the way we've
The
charged
court
it.
will take those, that is the second bullet point language out of the proposal. and the balance of the instruction on hindering.
Just on page 50, when we talk about the rendering criminal assistance, I think the word knowingly should be in there because I know it's in the definition, but when you're indicating it's in the element itself, it has to be knowingly rendered criminal assistance.
So I disagree with that. And this is what I was getting at earlier when I said there are certain offenses for which there's a general intent and a specific intent. I don't think that the defendant needed to know that murder is a Class A felony. I think she simply needed to know that the crime of murder had been committed and that she intended to aid Mr. Dulos in his endeavor to destroy evidence. And so I think adding the word knowingly there is misleading because it's suggesting, because it immediately follows, the second element is that she rendered criminal assistance to a person who committed a Class A felony. So by adding the word knowingly, it would be suggesting that she had to know it was a Class A felony, and I don't think that that is the law. And I would just ask the court again, well, I'd make the request to add back in general intent based on this count, because I do think it gets confusing. But that being the case, I don't have an objection to the language or a Class B felony or unclassified felony for which the maximum penalty is imprisonment for more than 10 years being removed because we've specifically alleged the crime of murder. So I don't think the court needs to instruct on a Class B felony or other felony.
And let me indicate, this is where I strongly disagree. The suggestion you can give criminal assistance and not, well, here's where I will agree. She doesn't have to know it's a Class A felony, but they charge it murder. So she would have to know she's assisting in offering criminal assistance to a murder. Otherwise, hypothetically, somebody, and this is again at the car wash, if she thought there was, I don't know, marijuana, because back in 2019, I think it was illegal in the truck, and that Fotis Dulos was going to clean it to get rid of maybe some leftover misdemeanor offense, this would not require that she understand that what she's allegedly assisting in, criminal assistance, is the crime of murder. Whether she has to know it's a Class A felony or not, I think it's pretty clear she has to know she's rendering aid to that crime.
Well,
And knowingly so.
well, the court thinks that the instruction is fairly clear. The second element, this is how the court revised the instruction. The second element is that she rendered criminal assistance to a person who committed a Class A felony. According to the law in Connecticut, murder is a Class A felony.
But doesn't she have to know that she's giving, as I understand the definition of criminal assistance, there's the, I believe there's this Rodriguez case, which I cite in my proposal. The court in the Rodriguez said the court has to instruct that the person know what the crime is that they're assisting.
So
Well,
they make that finding by finding beyond a reasonable doubt that she rendered criminal assistance. They don't need to find that she knew it was a Class A felony, just that she rendered criminal assistance. No, and they would have to make the finding that she did so with intent under your instructions. And it just so happened that the person committed a Class A felony, the person that she was rendering criminal. So I think that the court's instruction accurately states the law. I would actually ask for the additional language that the defendant does not need to know the classification of the felony.
Well, I not only disagree, I think the Rodriguez case made clear that it had to make sure that the jury understands, because like I said, if it's just criminal assistance of any sort, it doesn't require that they know what the crime is.
well, the court is inclined to revise the instruction to read this way. The second element is that she rendered criminal assistance to a person who committed a Class A felony. The defendant does not need to know the classification of the felony. According to the law in Connecticut, murder is a Class A felony. The jury has to know it's a Class A felony.
Correct.
The other instructions after hindering are essentially standard instructions for jury deliberations.
I have nothing on the balance of the instructions, Judge.
And other than noting that, you know, it would be my request that the court provide and give the instructions as I have provided them. I have nothing else.
Judge, I did make one proposal at the beginning, which we haven't yet addressed, which was charging in the conjunctive. I don't know if the court's inclined to give that instruction.
The court included that language somewhere else.
Okay, I didn't see it. You included it in when you were speaking about the accessory statute, I believe.
Right.
That was from the pattern instruction, but for example, hindering, I think it could be transportation and other means, but really it means or. So I don't know if the court wanted, and that's not part of the, she's not charged as an accessory with hindering. So I don't know if the court wishes to give this instruction just so the jury understands.
The court will consider it,
Very well.
because what the court does not want to do is have the jury stumble just at the beginning of deliberations over and or.
Sure.
So what the court intends to do is, by the close of business today, counsel will not be around, but have the proposed instructions ready to be emailed to counsel at the end of the day. As that concludes the charge conference, we will stand adjourned.
All rise.
Closing, is the court given any thought to whether the court's going to?
We can sit down for a moment.
Okay.
Radio and broadcasting. And the court understood from that time that in the half-hour newscast, the newscaster spoke actually without taking into account the stories by correspondence, 8 minutes. So the hour will be sufficient.
Okay.
We'll stand adjourned.
All right, guys, if you are just joining us, court just adjourned. We are coming back here tomorrow morning at 10 a.m. for closing arguments in the Michelle Troconis trial. So if you missed this morning, you can rewind and rewatch. They did go over the different instructions and arguing what is and isn't appropriate for jurors. But tomorrow is a big day. We'll see you guys at 10 a.m. Eastern time when closing arguments begin. I just wanted to say thank you to everyone for being here, for showing up, for watching this trial with us. Thank you to all 5,000 of you. It's funny because we look at 100,000 on the other channel and now 5,000 seems small, but 5,000 people is, I can't even imagine. I think at CrimeCon, when Joel was so overwhelmed by the amount of people that filled up an auditorium, there were like 2,500 people there. So like imagine a huge auditorium times 2. That's the amount of people that have been supporting this channel and showing up and watching along with us. So I just want to thank all of you guys for being amazing. All of our mods who are here every day, all day. And even when I miss out, they fill me in on everything going on. So I just wanted to thank all of you guys and let you guys know that tomorrow morning, 10 a.m., big day in this trial. Closing arguments begin for the Michelle Troconis trial. That photo that you guys are seeing there, most of you guys already are familiar with her and her story. This is Jennifer Farber Dulos. Let's always take some time to remember the victims. This was a 50-year-old mother who disappeared, was never found, and now her 5 children are left with no mother and no father. So again, thank you to all of you guys for being here. Please remember to hit the like button. We are going to be ending this stream We do have a show tomorrow night. We had a scheduling conflict that came up. So I believe the topic is changing. So stand by, but we do have a live show tonight, I think at 7 p.m. Eastern time. We're going to have that updated in the next 45 minutes or so. So please remember to check the main STS channel, turn your notifications on, and thank you to everyone. Hope you have a great day or a great evening if you're overseas. Take care.